okay, wenn wir hier stehen?
Ja,
okay, cool. Danke. Danke, danke. Na, können wir uns noch hier zwischen quetschen. Könnt ihr gerne tun, oder hier vielleicht irgendwo da runter gehen, da sind die Kollegen hinter uns. Ah, okay, okay. Aber, ja. Was wann seid ihr dran? Ihr seid ja eh was. 11, 11:15 Uhr. Achso, da haben wir auch. Ja. Ah, ne, wir stellen uns an. Wir stellen uns auf die andere Straßenseite. Hier, wieder. Jo. Kriegsbemalung oder nicht?
Bitte?
Kriegsbemalung?
Ein bisschen was hier vorne glänzt, ein bisschen Puder. Always appreciated.
Also wir rechnen damit, dass der oberste Gerichtshof hier eine Unterscheidung macht. Was sind die Handlungen eines Präsidenten, die er aus seinem Amt heraus als Präsident für das Land eben vornimmt? Und was sind die Handlungen, die er aus purem Eigeninteresse vorantreibt? Zum Beispiel, wenn er einen Anruf macht an einen Wahlbeamten in Georgia und versucht, die Wahl zu seinen Gunsten zu verändern, dann ist das eigentlich kein offizieller Akt eines amerikanischen Präsidenten, sondern Privatsache, weil Donald Trump eben diese Wahl doch noch gewinnen möchte. Diese Unterscheidung. Boah, ich habe meine Sonnenbrille vergessen.
Okay, dann können wir jetzt nochmal. Jeder, der möchte, gerne. Da sehe ich Schatten, da sehe ich Schatten. tatsächlich, der Präsident fährt irgendwo hin, was ist das denn genau, das kann man nicht sagen, räumen den Tag aus. Oder auch je nachdem, wer da ist, da sind ja Secret Service unterwegs, National Park Police, ja, verschiedene Leute, und da hast du manchmal halt die haben gerade WhatsApp gelesen, ja, und wurden die alle nerven, und die können ja wirklich, und dann einen kommt, sagt ihr das National Park, die gehst du halt, ne? Meistens geht, aber das ist ja wohl weg. Das wird dir dann auch nicht, man kann aber versuchen, ein bisschen zu reden, aber oftmals klappt es nicht.
Ich bin da vorne mal im Schatten. Ne?
Well, he said he was coming over later. He said he's coming over later, so he's done his own.
Ich habe jetzt mal die kleine Kamera genommen. Die haben wir das schon so eine kleine. Und ich habe mir ehrlich gesagt vorgestellt, dass es nur das Gewehr ist.
Yeah. I told him all that. Okay, bye. That's Robert. How you doing? Yeah, I got it. Yep. Okay. Yeah, you're welcome. Bye. Yeah. No, that's the easiest way to do it.
Ja, usually I will go by the
Cool, danke. Bis später.
Fabian, magst du da mal ein bisschen drehen? Die Entscheidung ist gerade gekommen. Die verteilen gerade die Zettel.
Okay.
10 Minuten einfach nur ein bisschen da rumgehen und verteilen da gerade die Zettelchen. Ich halte hier bestimmt. Gibt's jetzt Reaktionen wahrscheinlich? Weißt du?
signal up on the Euro 17.
Mix it up a little bit, yeah. It's shameful.
I'm here because every year on Tuesday, the Hokies time, I think that's what the
until after the election, but it also squarely holds a few of the things that he did are either absolutely immune or entitled to the presumption of absolute immunity, including what is absolutely immune, his discussions with Justice Department officials, including threatening to fire Acting Attorney General Jeff Rosen. That would also make it true that a future president could do exactly that, threaten to fire his Attorney General or replace him with someone else. Anyway, presumptive immunity goes to his pressure campaign on the vice president, based on his role as president of the Senate that day in helping to certify the Electoral College vote. Justice Sotomayor is reading from her dissent. I haven't talked at all about the dissent, so let's briefly look at that. For those who are new or joining, largely a win for former President Donald Trump here at the Supreme Court. The court holding that a president is absolutely immune from criminal prosecution for official acts as president, and he's entitled to presumptive immunity for official acts, or for acts that may fall within that category. All right, so the top of the dissent here, this is a 6-3 split along ideological lines. Today's decision to grant former president criminal immunity reshapes the institution of the presidency. It makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. Relying on little more than its own misguided wisdom about the need for bold and unhesitating action by the president, the court gives former President Trump all immunity he asked for and more. Because our Constitution does not shield a former president from answering for criminal treasonous acts, I dissent.
Helping your phone at all?
No, but I could hold it. I can hold it.
It's like so windy, it might screw you up.
Let's see. Ooh. Okay, you guys, I'm going to hold this while I'm also talking to you. All right, I'm reading from the dissent. The indictment paints a stark portrait of a president desperate to stay in power. In the weeks leading up to January 6, 2021, then President Trump allegedly spread lies that there had been outcome determinative fraud in the election and that he had actually won, despite being notified repeatedly by his closest advisors that his claims were untrue. When dozens of courts swiftly rejected these claims, Trump allegedly pushed officials in certain states to ignore the popular vote, disenfranchise millions of voters, dismiss legitimate electors, blah, blah, blah. Speaking to the crowd, Trump falsely claimed that based on fraud, the vice president could alter the outcome. This is the backdrop against which this case comes to the court. So she kind of walks through all of Trump's indicted actions leading up to and on January 6th. The court now confronts a question it has never had to answer in the nation's history: whether a former president enjoys immunity from federal criminal prosecution. The majority thinks he should, and so it invents an atextual, ahistorical, and unjustifiable immunity that puts the president above the law. The majority makes 3 moves that, in effect, completely insulate presidents from criminal liability. First, the majority creates absolute immunity from presidents' exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute, under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official acts immunity is inconsistent with text history and established understandings of the president's role. Moreover, it is deeply wrong, even on its own functionalist terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the president's illogical and evidentiary holding is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and our democracy. The main takeaway of today's decision is that all of the president's official acts defined without regard to motive or intent are entitled to immunity. That's the dissent from the liberal justices delivered by Justice Sotomayor, one of her many dissents this term. More points from the Roberts decision opinion. The court, this is from Amy in the live blog. The court indicates that the president's immunity for official acts extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. And in determining what is or is not an official act, courts may not inquire into the president's motives. So they can't try to see if he did something with corrupt intent. And an action is not unofficial, the court adds, just because it allegedly violates a generally applicable law. So the president can violate a generally applicable law, but that doesn't make his action unofficial. So he would be immune from that. Really a resounding win for former President Donald Trump here. Okay. Questions? Or do you want me to just keep reading? Can I explain more about the motive? The court is basically saying that when they're trying to figure out if an act is official or unofficial, they cannot look into the motive for a particular act, and that immunity applies at the outer bounds of the president's authority. They can't look into the motive of that official act. Did you say you have a phone charger?
Yes, right here.
Oh, can I plug in my phone? Because I am at 10%. I just got a 10% alert. Okay.
Is it charging?
Yeah.
Okay. Your other phone has some juice now.
Okay.
See?
All right. And in determining what is official conduct and which is not, which matters because official conduct is absolutely immune, including at the outer bounds. But in determining what's official and what's not, the court may not inquire into the president's motives. So if they're looking at an action, they just have to decide on its face if it falls within an official act. They can't look at the motive, for example, for why he's pressuring the vice president to stall the Senate's certification of the Electoral College vote. Presumably, they don't provide that example, or I haven't read it, but that would be an application of that principle. And in determining an action is not unofficial, meaning subject to immunity, just because it allegedly violates a generally applicable law, meaning the president can violate a generally applicable law and still be subject to absolute immunity, still enjoy absolute immunity. The court also notes in a footnote that the district court, if necessary, should consider whether two of the charges brought by Jack Smith in Washington involving obstruction of an official proceeding can go forward in light of the court's ruling last week in Fisher v. United States, narrowing the scope of that law. I think that is a strong indication from the Supreme Court that Jack Smith's charges, 2 of the 4, involve obstruction of an official proceeding and likely do not work in this case. So that would cut this down to a 2-count indictment, and the court would then have to piece through all of the official acts that are now absolutely immune from prosecution that cannot be used in an indictment. Even if they are facts that are relevant and they're not charged, they cannot be used. Justice Sotomayor is still reading from the bench. So, recap of the court's decision. That is a resounding win for former President Donald Trump here, the more I read. An absolute win, more than Trump even wanted, as the dissent points out. Presidents are absolutely immune from their official acts, and they are entitled to presumptive immunity for questionable ones. So, for example, the president's threatening to fire the acting Attorney General, Jeff Rosen, for Jeff Rosen not pressuring Georgia or getting GOP lawmakers to overturn the results there, is absolutely immune from criminal prosecution because his discussions with Justice Department officials are one of those core constitutional powers that the president enjoys and cannot be prosecuted. The pressure campaign on the vice president, there is a question, but the president enjoys the presumption of immunity, and prosecutors would have to rebut that. And then his discussions with state officials and his speech on January 6th and all of those things, the Supreme Court directs the lower court to, in the first instance, determine whether they are, in fact, official acts. But again, absolute immunity for official acts. It's the first time the Supreme Court has ever held that. No immunity for unofficial acts, but there doesn't seem to be much room for official acts here. And in determining whether an act is official or unofficial, the court can't look at the president's motives, which is a big point. Justice Sotomayor is... Jackson has omitted respectfully from her separate dissent. She's wrapping up her dissent. Ooh. So, questions? They do provide guidelines for what is official and unofficial. Somebody's asking if the court's providing guidelines here. They are, in fact, holding that his discussions with Justice Department officials, threatening to fire Acting Attorney General Jeff Rosen because he wouldn't help him overturn the Georgia results, is absolutely immune from criminal prosecution, because discussions with his Department of Justice is part of that core constitutional power that the court says cannot be prosecuted. So none of those facts related to those conversations can be used in a prosecution. They also tell the lower court he's entitled to presumptive immunity for his discussion with the vice president about the vice president's role as president of the Senate on January 6th, certifying the Electoral College result, and that prosecutors would have to rebut that presumption, meaning prosecutors have to do work to overcome Trump's default immunity there. And then for his discussions with state officials, other public officials, conversations from the White House on the phone, and his speech on January 6th and things he said in tweets on January 6th and leading up to January 6th, the lower court will have to determine in the first instance if they are entitled to prosecution immunity. The dissent here saying that this makes a mockery of our constitutional system, and that the Supreme Court basically gives Trump what he wanted and more. Justice Jackson also writes a separate dissent and omits respectfully from that dissent. Now, this is the end of Sotomayor's dissent. Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. We fear for our democracy, I dissent. Is that Sotomayor? Yeah. Oh, she doesn't respectfully dissent. She just dissented. With fear for our democracy, comma, I dissent. Typically, justices put respectfully dissent at the end of their opinions. That is an intentional choice. Justice Jackson also, at the end of her opinion, says, in the meantime, because the risks and power the court has now assumed are intolerable, unwarranted, and plainly antithetical to bedrock constitutional norms, I dissent. Neither justice respectfully dissents. Roberts is now wrapping things up. We're going to get the cleanup conference order list tomorrow morning at 9:30. And the justices are leaving the bench. And that is a wrap on the merits docket. So actually, recap, we got other decisions today from the Supreme Court. We got 2 other decisions. One, the Supreme Court decided a case called Corner Post, which has huge ramifications for when you can bring challenges to an agency's decision-making, rulemaking. If it sounds like Chevron, it's because it actually has an impact similar to Chevron, overturning Chevron. The Supreme Court said that a claim accrues for you to challenge an agency rulemaking, so a decision about air cleanliness or road and bridge transportation or whatever, whenever you are injured, not when the agency makes the rule. That matters because the people challenging the the Federal Board of Governors here, are challenging a rule that was made before they were even in business. So this will allow challenges to be brought kind of in perpetuity, which could crush the federal government, as the dissent said, or it could constrain the administrative state, as the majority said. That was the first decision. The second decision we got today was kind of a loss for the Social Media Trade Association, who is challenging Florida and Texas laws trying to restrict their rights to content moderate. These laws were basically telling the social media companies they couldn't take down certain content, largely conservative content. Through a trade association, tech companies like Twitter, Google, Facebook said that that is a facial violation of the First Amendment, their right to decide what speech appears on their platform. And the Supreme Court said, no, you can't really make that facial challenge without doing some more digging here. A facial challenge means every possible application of the law is unconstitutional. And the Supreme Court says there's reason to believe there could be some applications of that law to some media that could be constitutional, so you send it back down. The facial challenge comes at a cost, as Justice Kagan said. And then, of course, in the final decision today, we got Trump immunity, where the Supreme Court, for the first ever time, held that a former president is entitled to absolute immunity from criminal prosecution for all official acts while president. More than that, he's entitled to presumptive immunity, and that he doesn't enjoy immunity from unofficial acts, but leaves a very small window for what those acts could be and how a court could even determine what unofficial acts are, saying, and even determining whether it's an official act or an unofficial act, the courts cannot look at the intent or his state of mind, whether he had corrupt intent. They can't look at his motive when they're trying to determine whether it's official or unofficial. So it's largely a win for former President Donald Trump. It closes the door on any possible trial before the election and possibly thereafter. They also, in a footnote, point out that the court should reconsider the application of 2 of the 4 criminal charges he's facing in the January 6th case, obstruction of an official proceeding, because earlier the court said that that obstruction charge doesn't apply in the case of Jeffrey Fisher from January 6th and likely may not apply in former President Trump's case. And that's possibly a nod from the court saying these 2 charges probably do not apply here, reasoning that that charge was created after the Enron scandal in the early 2000s and was meant to go after the destruction of physical documents or physical evidence, documents, records, papers. And so applying it to the certification of the Electoral College vote and Congress meeting that day doesn't work. And that likely also applies in former President Trump's case because 2 of the 4 counts in the indictment he's facing are related to obstruction of an official proceeding. And the court footnotes that, but is basically saying the lower court, take a long, hard look at this here. So if Jack Smith is only left with 2 charges and now the absolute immunity for a lot of the conduct and presumptive immunity for more of it, it's a very tough case to make.
How are you doing?
Good. How are you?
Want a hand?
Oh, I'm fine. I think I'm good.
Let me give you a hand.
I'm going to sign off soon, probably.
Son of a. You have to have muscle for this.
All right. Questions? You're welcome. You're welcome. There are no more decisions coming. That is it. Now, it is the summer before an election, so there will be shadow/emergency docket challenges leading up to the election. You're welcome. What does this mean for former presidents? All former presidents and all future former presidents enjoy absolute immunity for their official acts and presumptive immunity in determining what's official and not official. Let's look at the presumptive immunity language briefly. Okay. I'm just going to where the court describes the presumptive immunity. We conclude that under our constitutional structure of separated powers, the nature of presidential power requires that a former president have some immunity from criminal prosecution for official acts during his tenure in office, at least with respect to the president's exercise of his core constitutional powers. This immunity must be absolute. As for his remaining official actions, I see. So official actions, core constitutional powers, absolute. Official acts, not entitled. He's also, as for his remaining official actions, he's also entitled to immunity. At the current stage of the proceedings in this case, however, we need not and do not decide whether immunity must be absolute or instead whether a presumptive immunity is sufficient. Okay, so core constitutional powers, absolute immunity. Other official acts, either absolute or presumptive immunity, but they're not deciding which. And then no immunity for unofficial acts. Taking into account these competing considerations, we conclude that the separation of powers principles explicated in our precedent necessitate at least a presumptive immunity from criminal prosecution for a president's acts within the outer perimeter of his official responsibility. Somebody's going by with a speaker. Hang tight. The split was 6-3 along ideological lines. Okay, I was just reading about the presumptive immunity from criminal prosecution. Indeed, if presumptive protection for the president is necessary to enable the effective discharge of his powers when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. At a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. That is a high bar. I'm going to read that again. I'm just clipping the important sections for myself for the future. So I'm just rereading this. So again, absolute immunity for core constitutional powers. Immunity for official acts, but whether it's absolute or presumptive, to be determined. But here's the language for presumptive, which makes it quite strong. Such an immunity is required to safeguard the independence and effective functioning of the executive branch and to enable the president to carry out his constitutional duties without undue caution. Indeed, if presumptive protection for the president is necessary to enable the effective discharge of his powers when a prosecutor merely seeks evidence of his official papers and communications, it is certainly necessary when the prosecutor seeks to charge, try, and imprison the president himself for his official actions. At a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. No danger of intrusion on the authority and functions of the executive branch, citing Fitzgerald there. But as we explained below, at the current stage of the proceeding in this case, does not require us to decide whether the immunity is presumptive or absolute. Pretty high bar there. I'm thinking, well, we'll see what happens. Tough case. I think, yes, this is largely a win for Trump. Can it be overturned? It cannot. Today is the final word on presidential immunity. It could be overturned in 40 years, but today's the final word. So we got 3 decisions today. All of them are very important. The APA decision, very important. That a claim accrues when the injury happens, not when the rule is passed. The Supreme Court kind of sent back down the First Amendment challenge in the net choice cases because they made a facial challenge, meaning all applications of the law have to violate the First Amendment, and the Supreme Court says we don't know enough yet, so we're sending it back down. And in the Trump case, the holding is a president enjoys absolute immunity from criminal prosecution for core constitutional powers, including, as they say, his discussions with Justice Department officials at the time, referring likely to his conversations with Acting Attorney General Jeff Rosen. It's okay. It has been floating back a little bit.
Okay.
As for all other official acts that are not part of that core constitutional power, the president enjoys immunity, whether it's absolute or presumptive. They don't reach that. So his pressure campaign on the vice president is presumptive immunity, and the lower court will have to keep that in mind when they're discerning the difference between the two. And then unofficial acts do not enjoy immunity. So the court said absolute immune for discussion with Justice Department officials, presumptive immunity for pressure campaign on the vice president, for his discussions with state officials and conversations from the White House, his speech on January 6th, his tweets on January 6th and leading up to January 6th. The lower court will have to determine in the first instance whether those official or unofficial acts. The court doesn't say those are entitled to presumptive or absolute immunity straight out of the gate. And the court also drops a footnote saying that the lower court needs to consider whether, let's look at the exact language of the footnote that likely cuts two of the 4 charges he's facing. Trump contends that the indictment stretches Section 1512C2. As we explained in Fisher, Section 1512C2 covers acts that impair the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in the proceeding. If necessary, the district court should determine in the first instance whether Section 1512C2, obstruction of an official proceeding, charges may proceed in light of our decision in Fisher. Give it a close, hard look, because it didn't apply in Fisher's case. So just obstructing Congress that day is insufficient. So that would be 2 of the 4 charges in special counsel's indictment. All right, folks, it's almost 11:30. I think let's call it a wrap for the day. Can Jack proceed with DC now? Well, they're going to go back down to the lower court and argue about which actions are official and unofficial. They're going to have to redo some of the indictment because some of the alleged conduct is absolutely immune and can't be included. I don't know how that's going to work. Maybe they remove some of it from... I don't know how that works. I have to ask prosecutors that question. This doesn't affect the New York case. I don't think. Yes, the lower court will pick it up now, but that's going to take time, and then the lower court's decisions are going to get challenged, and the D.C. Circuit's going to hear oral argument, and then they could get appealed back up to the Supreme Court again. So, no trial this year, or we'll see. Oh, maybe it can affect the New York case. I don't know. I guess because he was in office when he was making some of the payments, so they have to determine. I don't know. Ask the CNN lawyers. Not anything he did trying to overturn the election results would be immune, but Some things that are alleged conduct in the indictment are absolutely immune. Some things in the alleged conduct in the indictment are entitled to presumptive immunity, and some things the court is going to have to look at and determine whether it is an official act of the president or not, and therefore covered by absolute immunity. Yes, I would imagine this affects the documents case. Yes, I would imagine this affects the Georgia case. The Georgia case is born out of a similar set of facts. Thank you, Shan. Who would decide an official act? Judge or jury? Judge, I think. Yeah, judge, because they're applying the law. Judge. How would this affect the documents case? He wasn't president. He was president when he had the documents. And deciding what to keep and what not, and there will be a hearing about what official acts are part of the conduct charged. All right, folks, I think I'm going to sign off until we meet again. Yes, there are already big cases for next term, the Supreme Court, and tomorrow we'll find out more. Tomorrow's the cleanup conference results, so we'll get more cases. The court will deal with some others. And the court has already decided to weigh in on whether states can ban gender-affirming care for minors. You're welcome. Thank you, guys. Very kind. I'm not planning on going live tomorrow, but maybe I will for the cleanup conference. We'll see. Thank you, Shan, for excellent moderation. All right, thanks, guys. Term recap. Yeah, maybe one day. Not today. That would take another hour and a half. All right. Have a good week, everyone. Happy July 4th.
Nice. We're still hot, streaming, so let me call and confirm. We're gonna break down and then
Okay.
Feel free to take off your mic, but we're still hot.
Okay.
How are you?
Good. How was it?
Good.
Good.
Longer than normal.
Yeah.
Good though. Not what I thought. Hey, am I good to break down from screaming? Katie is done with her. Oh, okay. Is that official?
What?
You will probably be in house for the rest of the day.
I'm losing it?